CBS News has obtained an audio recording, which is part of the classified documents case against former President Trump.
And the recording seems to contradict some of the former president's statements in the case thus far. CBS 2's Dick Brennan live now in the newsroom with more. Dick.
Well, Maurice and Christine, the recording from 2021 comes from an interview Trump gave to people working on a memoir of Mark Meadows. It could at the very least complicate Trump's defense or perhaps pose serious trouble.
Court records sealed under the heaviest judicial protection have suddenly been ripped open. Documents Trump's legal team fought with every weapon to keep buried forever, and they just lost that war. Federal judges looked at the secrecy claims, the executive privilege arguments, the national security objections, and ruled the game was over. The files are coming out, all of them, and Trump's legal team is reportedly in a state of undisguised panic. The sheer volume of material that has now been pried open is difficult to overstate. We are talking about internal White House communications that were never supposed to see daylight.
He said he wanted to attack Iran and what? He said this was done by the military, given to me.
Donald Trump describing a sensitive document he appears to be holding in the presence of two people who have no national security clearance. He's talking about a secret plan drawn up by the Joint Chiefs Chairman Mark Milley and the Defense Department in regards to Iran.
We are talking about the most sensitive classified documents recovered from Mar-a-Lago. We are talking about security camera footage that captures movements and actions that certain people desperately wanted to erase from existence. We are talking about grand jury transcripts where witnesses sat under oath with the threat of prison hanging over their heads and described exactly what happened behind closed doors. All of this material was protected by aggressive legal maneuvering that stretched on for months, with Trump's attorneys filing motion after motion, appeal after appeal, throwing every procedural roadblock they could imagine into the path of transparency.
There's breaking news just coming into the Situation Room right now. The Georgia election interference case against President Trump and others in their effort to overturn the 2020 presidential election results will continue, but with a new prosecutor. This comes after Fulton County Attorney Fani Willis was previously removed from the case.
And now, judges at multiple levels have systematically demolished those barriers one by one until nothing remained standing. The courts ruled that the public interest in understanding what actually happened, combined with the integrity of the criminal justice process itself, completely outweighed Trump's claims of privilege and his arguments about electoral interference. That is a legal finding of immense significance, one that will echo through law school textbooks for generations to come. The court's ruling was written in language so forceful and so unambiguous that it sent shockwaves through the entire legal community. The judges essentially stripped away every remaining procedural shield that Trump's defense team had been hiding behind and made it crystal clear that the era of excuses was over.
Criminal case against President Donald Trump is alive again with a new prosecutor. This is the case in the state of Georgia in Fulton County around the 2020 election, Donald Trump's efforts there, and an alleged conspiracy that he led or is alleged to have led with top officials, including Rudy Giuliani, advisors on his campaign.
No more hiding behind claims of executive privilege that stretched the doctrine beyond its breaking point. No more invoking national security concerns as a blanket justification for secrecy when the real motivation appeared to be shielding potential evidence of crimes from public view. No more arguments about prejudicing potential jurors as if the American people were too fragile to handle the truth about what their leaders had done. The court basically declared that enough was enough, that the obstruction had gone on long enough, and that transparency was going to win regardless of how much political firepower was arrayed against it.
All right, we do have breaking news in the Jeffrey Epstein investigation. Democrats on the House Oversight Committee, minutes ago, literally, releasing emails that they say were written by Jeffrey Epstein that explicitly, specifically mention Donald Trump by name and in context that we really haven't heard before.
The unsealed records reveal not just the mishandling of classified materials, though that alone would be devastating. They reveal something far more legally dangerous, deliberate, calculated obstruction. We are talking about active efforts to delete security camera footage that would have shown who was accessing storage areas and when. We are talking about coordination between Trump's defense attorneys and his personal aides to craft responses to investigators that were technically worded to avoid perjury.
The latest Justice Department's filings had us wondering here, a year after leaving office, just how many documents marked classified did former President Trump have at Mar-a-Lago? So we counted by the numbers. Our count starts in January when the National Archives received 184 classified documents, adding up to more than 700 pages of secret government information. Now in June, 38 more documents marked classified, filling 13 boxes, were turned over by Mr. Trump's legal team,
while being substantively misleading about what documents still existed and where they were hidden. That is not negligence. That is not a misunderstanding about classification procedures. That is a conscious, coordinated effort to impede a federal investigation. And if proven at trial, it carries consequences that include significant prison time and additional conspiracy charges stacked on top of the underlying offenses.
Let's see here.
Yeah.
I just found, isn't that amazing? This totally wins my case, you know. Except it is like highly confidential, secret. This is secret information. Look at this.
The recording appears to contradict Trump's recent claim that he didn't have any documents with him.
I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories.
Inside sources who have been tracking this case from its earliest days are using language that is strikingly consistent. They describe Trump's legal team as being in a state of total panic. And for once, that description is not partisan hyperbole or clickbait exaggeration. These are lawyers who constructed an entire defense strategy around the assumption that they could keep the most damaging evidence sealed, that they could fight the release of each document individually, that they could run out the clock through procedural attrition while maintaining a public narrative that the whole case was a politically motivated witch hunt built on evidence nobody could actually examine. That strategy has just collapsed in real time, and the panic is visible in every subsequent filing they have submitted to the court. They are scrambling for options that simply do not exist anymore, because the transparency orders have left them with no mechanism to block the avalanche of damaging material from entering the public record and being placed directly in the hands of prosecutors who are now building their trial strategy around evidence that everyone can see. This sweeping court order did more than just affect Trump's individual case. It established a new precedent for how executive privilege and secrecy claims are managed in criminal prosecutions involving former presidents. And that precedent is going to shape the legal landscape for decades to come. The judge who delivered the most decisive ruling used language that will be quoted in legal briefs for the rest of this century. He said that transparency wins. He said that the public has an absolute right to see what its government is doing behind closed doors when those closed doors are being used to shield potential criminality. He made it clear that there would be no more extensions, no more delays, no more creative legal arguments designed to push accountability past some political finish line where it would no longer matter. The forcefulness of that language tells you everything you need to know about the judiciary's patience with obstruction tactics that have been pushed well past their breaking point. Federal judges are by temperament and training cautious institutionalists who bend over backwards to accommodate defense concerns and protect the integrity of their proceedings. When they start issuing orders that read like declarations of war, it means they have concluded that the litigants on one side are operating in bad faith and need to be brought to heel. The evidence that is now public includes internal White House memos that reveal discussions about how to handle classified materials and whether specific documents should be returned to the National Archives or kept hidden from the government officials who were legally entitled to retrieve them. These memos demonstrate with painful clarity that multiple people in Trump's immediate orbit were fully aware that retaining these materials was legally problematic. They knew the documents did not belong to Trump personally. They knew the National Archives had been demanding their return for months. They knew the FBI was circling, and yet they made conscious, deliberate decisions to keep the documents anyway and to construct justifications for their retention after the fact. That level of awareness is absolutely critical from a prosecutorial standpoint because it goes directly to the element of intent. It is not enough to prove that classified documents were improperly stored. Prosecutors must prove that Trump knew what he was doing was wrong and did it anyway. These memos provide exactly that proof and they are now part of the public record where any potential juror can read them and draw their own conclusions. The Mar-a-Lago classified documents themselves are explosive in ways that go far beyond anything the public has previously been allowed to see. We are not discussing a handful of random papers that accidentally got swept into a box during a chaotic move out of the White House. We are discussing highly sensitive national security materials containing intelligence about foreign governments, assessments of military capabilities, and information about nuclear programs that are among the most tightly guarded secrets the United States government possesses. These documents were not stored in a secure facility with armed guards and biometric locks. They were stored in a bathroom. They were stacked in a ballroom at a private resort where members, guests, and staff circulated freely, any one of whom could have stumbled across them or accessed them for purposes that remain unknown. The unsealed records show that Trump's team was informed repeatedly by the National Archives and eventually by the FBI itself that these documents needed to be returned immediately and that their continued retention was a violation of federal law. Instead of complying, there were active, documented efforts to move boxes from one location to another, to hide materials when investigators were scheduled to arrive, and to delete the security camera footage that would have shown exactly who was doing what and when. That is not carelessness. That is not administrative error. That is deliberate obstruction of justice, and it is the kind of conduct that federal sentencing guidelines treat with exceptional severity. The security camera footage deserves particular focus because it represents evidence that is virtually impossible to spin or explain away. According to the unsealed records, Trump aides were specifically directed to either delete footage entirely or to prevent federal investigators from ever gaining access to it. You have to stop and ask yourself the obvious question. Why would anyone do that unless they knew with absolute certainty that the footage would incriminate them? Innocent people do not destroy evidence that would prove their innocence. The very act of attempting to delete or obstruct access to this footage is itself powerful evidence of consciousness of guilt, and prosecutors know that juries understand this instinctively. The footage that has now been turned over to investigators and partially made public apparently shows precisely what the government's theory of the case predicted. People moving boxes of classified documents around the resort, relocating them to different areas, and timing those movements to occur just before scheduled searches or compliance checks. That visual evidence, combined with the internal memos and witness testimony, creates a picture that is devastating in its clarity. The grand jury interviews that have been unsealed add yet another layer of damning detail because they capture testimony given under the most serious circumstances the legal system can create. Grand jury witnesses are told explicitly that lying is a federal crime punishable by imprisonment. They understand that they are not having a casual conversation, but are participating in a formal legal proceeding where every word is recorded and can be used against them if they are later found to have been dishonest. The unsealed transcripts show that multiple witnesses, people who were inside Trump's inner circle and witnessed key events firsthand, described Trump's direct personal involvement in decisions about which documents to keep and which to return and how to respond to the government's increasingly urgent demands for production. They described conversations in which Trump expressed explicit awareness that certain materials were classified and should probably be given back, but that he wanted to hold on to them anyway for reasons that included potentially using them as source material for a future book or to support his personal version of events from his time in office. That is not speculation. That is sworn testimony from people who were in the room when the words were spoken. What makes the entire picture even more legally treacherous for Trump is the evidence of active coordination between his defense team and his personal aides to mislead investigators about what documents existed and where they were located. The unsealed records apparently contain communications in which lawyers and aides discussed precisely how to respond to subpoenas in ways that would be technically true, while being substantively deceptive about the full scope of what materials Trump still retained. This kind of coordination transforms what might have been charged as a single individual's poor judgment into something far more serious, a conspiracy involving multiple people working in concert to impede a federal investigation. Conspiracy charges carry their own independent penalties, and they make it vastly more difficult for any individual defendant to argue that the whole situation was just a misunderstanding or an honest mistake. When you have multiple people coordinating their stories and their actions toward the shared goal of preventing investigators from discovering the truth, the innocent explanations simply evaporate. The panic consuming Trump's legal team is entirely rational when you examine how comprehensively this unsealing has demolished virtually every defense strategy they had spent months constructing. Their entire approach was built on a foundation of procedural obstruction. They argued that much of the evidence was obtained improperly and should be suppressed. Those arguments were rejected. They argued that large portions of the evidence should remain sealed to protect executive privilege and national security. Those arguments were rejected. They argued that releasing the evidence would prejudice potential jurors and interfere with political processes. Those arguments were rejected. Every single procedural shield they tried to erect has been knocked down. And now the evidence is not only available to prosecutors, but is visible to the entire public. The defense can no longer rely on keeping the most damaging information away from the jury pool through motions to suppress or seal. Everything is out in the open, and there is no mechanism for putting this particular genie back inside the bottle. Courtroom observers who were physically present when the unsealing orders were delivered described Trump's lawyers as being visibly caught off guard by both the scope and the speed of what happened. They had apparently expected to continue fighting a war of attrition, negotiating over each individual document release, buying months of additional time through the endless appeals process. Instead, the judges essentially told them that the era of piecemeal litigation was finished. They released everything simultaneously in one overwhelming wave and told the defense to deal with the consequences. That kind of aggressive judicial action is extraordinarily rare in high-profile cases where courts normally bend over backwards to accommodate defense concerns about fair trial rights and pretrial publicity. The fact that multiple judges were willing to take such an uncompromising stance tells you that they had reached the limits of their patience with what they perceived as bad faith litigation tactics designed not to protect legitimate rights, but to indefinitely delay accountability. The precedent being established here regarding executive privilege is going to reshape how future criminal cases against high-level officials are litigated. Courts are now on record saying in the clearest possible terms that executive privilege is not a magical incantation that makes evidence of criminal conduct disappear. It cannot be deployed as a blanket shield to hide documents that would be embarrassing or incriminating. The public interest in transparency and accountability, particularly when serious crimes are alleged against the very officials who once held the highest offices in the land, outweighs generalized claims of confidentiality. This represents a significant narrowing of executive privilege from the broad protective doctrine that presidents and their lawyers have asserted for decades. Future occupants of the White House will now operate with the clear understanding that their internal communications are not permanently immune from scrutiny, and that if those communications contain evidence of crimes, the judiciary will eventually force them into the light. For prosecutors, the practical implications are immediate and profound. They now possess evidence they spent months fighting to obtain, and that evidence appears to be extraordinarily damaging. They have documents establishing awareness and intent, the two elements that are always the hardest to prove in cases involving classified information and obstruction. They have witness testimony from individuals who were present for the critical conversations and decisions. They have video footage that visually corroborates the government's timeline and theory of the case. They have communications between Trump, his lawyers, and his aides that demonstrate coordination to mislead investigators. This is the kind of evidence package that prosecutors dream about building, and it is going to be exceptionally difficult for any defense team to overcome at trial, regardless of how skilled or well-funded they are. The defense team's remaining options are shrinking rapidly. They cannot argue the evidence was illegally obtained because judges have affirmed the validity of the underlying warrants and subpoenas. They cannot argue the evidence should be suppressed based on privilege because those privilege claims have been exhaustively litigated and rejected. They cannot rely on delaying tactics because the courts have signaled they will not tolerate further obstruction. What remains is essentially a battle over interpretation, an argument that the evidence does not truly prove criminal intent beyond a reasonable doubt despite how damning it appears on its face. That is a much weaker position than the procedural fortress they had hoped to maintain, and it enormous pressure on their ability to craft a narrative that somehow explains away documents, testimony, and video footage all pointing in the same incriminating direction. The political dimensions of this unsealing are also immense. For months, Trump and his supporters have been able to claim that the prosecutions were politically motivated witch hunts based on secret evidence that nobody could examine because it was all sealed. That argument has now been stripped of its foundation. The evidence is public. Anyone can read it. Anyone can watch the footage. Anyone can assess for themselves whether criminal conduct occurred. The court of public opinion, which had been operating on faith and partisan allegiance, is now being asked to grapple with actual facts and actual documents. Members of Congress who previously stayed silent because they did not want to appear to prejudge sealed cases now have access to the underlying materials and can speak about them openly. Oversight committees will almost certainly launch additional investigations into how classified materials were handled and whether existing procedures need fundamental reform to prevent similar abuses in the future. The media coverage of this moment has been strangely muted in some quarters, perhaps reflecting a broader exhaustion with the sheer volume of Trump legal stories that have accumulated over years of investigations and indictments. But this particular development is genuinely different from what has come before. It is not another incremental step in a slow-moving process. It is the moment when the dam broke and everything that was hidden became visible. Judges explicitly declared that the defense strategies were insufficient to block transparency, and that declaration alone is news of the highest order. It speaks to whether the legal system can hold powerful people accountable under the same laws that govern everyone else, and that question is fundamental to the survival of democratic governance. The special counsel's office appears to be moving toward trial with deliberate speed now that the procedural obstacles have been cleared and the evidence they need is fully in hand. Prosecutors understand that delay creates risks. Witnesses can change their stories. Evidence can be lost. Political winds can shift in ways that make aggressive prosecution more difficult. With everything unsealed in public, the incentives favor moving forward quickly while the evidence is fresh and the momentum is on the government's side. Trial dates could be set relatively soon, which would place Trump in the extraordinary position of facing active criminal proceedings during the peak of a political cycle, a convergence that has no precedent in American history and creates complications that are impossible to fully predict. The impact on Trump's broader legal exposure is also worth considering. Success in one prosecution tends to embolden prosecutors in other matters. If judges in the classified documents case are willing to reject executive privilege claims and order mass unsealing, prosecutors handling the January 6th investigation or the election interference case or the financial fraud inquiries may feel empowered to push for similar transparency in their own domains. There could be a cascading effect in which Trump faces simultaneous evidence dumps across multiple jurisdictions, overwhelming even the most sophisticated and well-resourced legal defense operation. For Trump personally, the stakes could not be higher. The federal sentencing guidelines for mishandling classified information and obstructing justice allow for decades of imprisonment, particularly when aggravating factors like abuse of a position of trust are present. Realistically, a former president would likely not receive the maximum sentence even if convicted on all counts, but even a fraction of the statutory maximum would represent a stunning fall from the pinnacle of power and would effectively terminate any remaining political ambitions. The broader implications for American democracy are perhaps the most significant dimension of this entire story. For generations, the country has operated under an unspoken assumption that former presidents would not face criminal prosecution, partly out of respect for tradition and partly out of fear that such prosecutions would create dangerous precedents that could be weaponized for political persecution. What this case demonstrates with unmistakable clarity is that when there is clear evidence of serious criminal conduct, the justice system is capable of moving forward with prosecution regardless of the defendant's former status. Courts will not permit executive privilege or political considerations to serve as permanent shields against accountability. That principle is absolutely essential if the nation is to maintain any credibility as a country governed by laws rather than by the whims of powerful individuals. The judges who ordered these records unsealed in the face of enormous political pressure and relentless legal opposition deserve recognition for their commitment to the core proposition that no person is above the law. They understood that public confidence in the justice system depends entirely on the perception that the same rules apply to everyone and that powerful defendants do not receive special treatment simply because of who they are or what office they once occupied. This mass exposure of Trump's most closely guarded secrets represents the collapse of the final barriers to full accountability. The legal team's panic is not a performance, and it is not a strategy. It is the genuine reaction of lawyers who have just watched their entire defense collapse in real time, who understand that the normal strategies are no longer viable when everything is out in the open, and who can see with painful clarity exactly where this prosecution is heading. The country now finds itself in genuinely uncharted territory, watching the legal system attempt something that has never been attempted before: the criminal prosecution of a former president based on overwhelming evidence that the public can now examine for itself. The panic in Trump's legal team is justified because they know what everyone who has followed this case closely also knows. The shields are gone, the secrets are exposed, and the judges have made abundantly clear that the era of obstruction and delay is finally irrevocably over.